Hello, everyone, and welcome to this Legal 500 webinar in partnership with ICT Legal Consulting, Legal Cybersecurity Landscape, how to create an effective and integrated privacy and cybersecurity compliance framework. My name is Joe Boswell. I'm a senior member of the Legal 500's in-house legal research team, and I'll be introducing today's session. We're very lucky to have an excellent panel here to discuss our topic for the next hour or so, as they examine in detail some of the issues at the forefront of the cybersecurity world. This session is interactive, so if you have any questions at any point during the webinar, please type these into the Q&A function and our panel will do their best to answer them. I'd now like to throw over to Paolo from ICT Legal, who's going to lead the discussion today.
Well, thank you very much, and good morning or good afternoon, everybody. My name is Paolo Balboni, and I am one of the founding partner of the international law firm ICT Legal Consulting. Together with me, we have connected from Australia, the managing partner of ICT Legal Consulting Australia, Elaine Legert. Welcome, Elaine. And we also have connected from Italy, from our company ICT Cyber Consulting, Francesco Capparelli, that is our Chief Cybersecurity Advisor. Welcome, Francesco.
Hello, Paolo. Thank you.
Before to start, just a brief introduction. ICT Legal Consulting is actually more than a law firm, because we also have a company that offer cybersecurity consulting services. But basically, we are focused on privacy, data protection, ICT, and intellectual property. And we strongly believe that the only way to do our legal consulting activities is to merge them with technical expertise, cybersecurity expertise, to make sure that we deliver the full package, especially around the data-driven economy. So allow me to share now our presentation. I assume you can see it properly. And let's get started. What is actually the purpose of today? So purpose of today is that we see the legal framework mainly in Europe, but also at the international level. And Elaine will discuss a little bit more about what is happening outside the European Union. And Francesco and I will talk more about the European legal framework. But anyway, we see, the thrilling development of privacy and cybersecurity legal sources. So what we have experienced with our client is that there is, let's say, a development of sometimes two different frameworks, like the privacy framework on the one side, the cybersecurity framework on the other side. And we need to make sure that the two can be integrated, that our clients will be able to maximize the effort, so that if you create a data protection compliance framework, you can also leverage what you have done with respect to, making your group also cyber secure. And if you are doing compliance activities with respect to cybersecurity, that you can fully leverage it on the data protection compliance point of view. So therefore, we need to work on an integrated privacy and cybersecurity compliance framework. And today is just about that and giving you some tips and sharing some information. So we do that introducing a little bit of stats on cost of breaches to make you appreciate also the impact, the financial impact of having the protection for a group not adequate, or the cost of not duly managing a data breach or a security incident. We all know, as a professional of cybersecurity, that it is impossible to have 100% secure systems or a secure environment, but it's key to be able to be resilient. Resiliency is one of the key elements of cybersecurity and information security in general, so that anytime that an organization is under an attack or under a possible threat, keeps the business operations and make sure to restore the state of play as soon as possible, minimizing the risk both for the business operations and also for the citizens, also called data subjects in this domain. Then we go to share with you what is, the privacy and cybersecurity framework in Europe and also in Australia, and with a little bit of touch, even outside Australia, the international level. We focus on the main sanctions under the GDPR, specifically focus on violation of Article 32, 33, and 34, so mainly with respect to data security. And then I will hand it over to my colleague Francesco Caparelli to deep dive into the methodology to create an integrated privacy and cybersecurity framework. And we close quantifying the return on investment on exactly invest on privacy and cybersecurity. Anytime, feel free to pose questions. We'll try to do our best to address them. So first of all, some numbers. As you may have appreciated, the COVID-19 situation have done nothing but increasing cybersecurity weakness of organizations. The reason is fairly simple. At the beginning of 2020, the vast majority, if not all organizations, were forced to go remote, and therefore to start to have this different way of doing business, different way to allow people to access data from the resources of a company by this remote connection. But the point was that everything had to happen so suddenly that very few organizations were really prepared in terms of security and cybersecurity to protect the information of the company, to make sure that the connection was secure, to make sure that even the behavior of the individuals, of the employees at home was adequate, fit to maintain the security and confidentiality of the information and the personal data related to the business. So we had witnessed an enormous amount of data breaches, an enormous amount of attack, systematic attention on specific sectors that we're going to touch upon in a minute, and also the feeling by the individuals, by the employees that by working remotely, they were not feeling even secure themselves. Think about some issues related to cybersecurity with respect to meeting platforms and online conferencing platforms and so on and so forth. So it's very difficult actually to really estimate the risk in the cybersecurity arena. That has been confirmed also by a recent study of NISA. NISA is basically suggesting that given this very fast development of technology, even think about artificial intelligence and how artificial intelligence has been leveraged by cyber attackers in order to increase the volume and the power of attacks on companies' systems. So the swirling development of technology is also making very difficult to estimate what is the cyber threat landscape and to correctly evaluate the risks in order also to budget for that, because we need to take into consideration as business lawyer that in order to invest into cybersecurity and data security, you also need to make an estimate. And to make an estimate, you need to evaluate the risk. And evaluating the risk now is a little bit of a moving target because of this, very fast development of attacking techniques and so on and so forth. But nevertheless, towards the end of the presentation, when we talk about return of investment, we'll try to share with you some methodology also to estimate that. The cause of data breaches, when we look at the data shared by IBM in a very recent security report, are 50% related to malicious attack. So the most traditional way to look at data breaches. So an attack from the outside, and definitely in the last year, ransomware as booming, or phishing attack were booming. But if you look at the left side of this chart, you will see that actually human error is 1/4 of the reason, the cause of data breaches. And system glitches, 25%, another 1/4. But I would focus on the human error because it's the most difficult to prevent, the most difficult to mitigate. Because regardless of how much spending a company has made in order to secure the systems, the infrastructure, the platform, the applications, but not a lot of focus, according to our experience, has been paid to employees. Which are actually the weakest link in terms of cybersecurity. And also directors, managers, we see like spear phishing attacks or phishing attacks completely targeted to the top management of companies, exactly in order to, you know, hit the most vulnerable people, because they are the one that needs to process the most email per day, and they have the least attention, you know, to try to discern what is a true email and what is not, resulting in massive attack with massive damages for companies. So here's some stats again from NISA, and there is one striking one. On average, an organization takes 6 months in order to realize, to detect a data breach. And this is scaring, but this is also very true, because we also have witnessed that you know, sophisticated attacks will imply that, you know, silently the attacker start to get inside the system, and then through lateral movements start to get in control of different applications and gain more and more power, so that he or she is even able to delete evidence of what he has done through, you know, the weeks and the months, making them very difficult when a company is realizing that is under attack to do the root cause, a proper root cause analysis, because sometimes evidences are not there anymore. And if you cannot make a full-fledged and accurate root cause analysis, it's very difficult then to put in place mitigation measures and, you know, to react and start to defend yourself, because you don't know anymore where the attacker is at some point in time, or it's going to cost a lot of time. And in that moment, you know, the attacker has a lot of negotiating power with respect to the company. So that's another point to be underlined. And of course, like anything related to try to understand and to protect the companies from attacks and signal, you know, possible malicious activities from inside is really, really important in terms of security measures to deploy. With respect to the typical sectors, we have seen an increase in attacks in the financial sector, especially banking and finance, the insurance sector as well, the healthcare sector, government and public administrations, definitely very much targeted in the last year and a half. Here are some, you know, top 15 cyber threat of NISA. I want to underline again the phishing part, because it's, you know, it's the softest way to get in, and one of the most pervasive, one of the most difficult to detect in terms of attack. And here we really want to underline how important it is to do awareness. We do, you know, with the ICT Cyber Consulting, a regular campaign on our clients, phishing campaign, Fish Me services, whereby you know, we test the readiness of an organization to try to react or to detect and react to phishing attacks. We think this is really key to be done, especially, you know, in this situation where the people are still working remotely and the phishing attacks are, you know, so heavily deployed by attackers. On the other side, here more on the legal point, we see that data breaches have been by far one of the highest cause of sanctions when we look at violation of the GDPR. We're going to get to that a little bit later on in the presentation. But it's also important to understand that, you know, through a data breach, so a violation of personal data, then usually you also get the attention through notification of the Data Protection Authority. And then the Data Protection Authority will get, you know, into an investigation or asking information and do a root cause analysis in order to understand whether the security measures in order to prevent the breach were adequate or not. And if they were not adequate, issue a sanction according to the principle of confidentiality and data security in Article 5 of the GDPR, and more specifically on violation of Article 32, adequate security measures of the General Data Protection Regulation, you know, amounting to fines that are you know, above 10 million euros. We're going to see that in a few minutes. So data breaches are definitely on the rise. That we have seen, a constant increase even before the pandemic, and then there was a real boom during the pandemic. So last year and a half. The cost, this is important for you to appreciate. So for large enterprise, the typical cost of a data breach is 173 euro per employee, whereas a smaller organization coherently will pay more per employee. But still, I think it's very important to bring these numbers to the top management of an organization to say, we really need to have a budget in order to invest on technology, system securities, training in terms of making awareness inside the organization to protect the employees from phishing attacks, to recognize them, to teach them which are the correct behavior in terms of correct information security management according to the principle of the well-known ISO 27001, and so on and so forth, as well as getting the right legal advice to put in place organizational, contractual measures, policies to correctly manage an incident that may result in a data breach. So let's now dig after this introduction into the privacy and security framework. We start with Europe, and then I will leave it to Hélène. Well, first and foremost, let's look at the GDPR, General Data Protection Regulation. There are some key provisions here. So we start from the principle of integrity and confidentiality, one of the main principles set forth in Article 5 of the GDPR. In a nutshell, anything that a controller or a processor does in terms of processing personal data must actually assure integrity and confidentiality of those personal information. Then a specification of this principle is set forth in Article 32 about adequate security measures. So Article 32 is all about risk assessment. You need to assess the risks on the rights and freedoms of individuals, but you also need to assess the security risk. This is important. It's already a signal of convergence between cybersecurity framework and data protection compliance framework. Typically in the cybersecurity framework, you're going to assess the security risk on business continuity, disaster recovery, and so on and so forth. But on the privacy framework, you're going to assess the risk of possible identity theft or discrimination, the so-called privacy risks. But in order to do something integrated, you need to assess them at the same time, not having two completely different exercises, and make sure that those exercises will come together coherently, so that the mitigation measure will be good to mitigate the cyber risk and good to mitigate the privacy risk. So this is the first and foremost point of contact between this integrated approach. The risk engine, the risk assessment engine, security and privacy needs to be coherently put together so that as the mitigation measures. Other two important sections of the GDPR, of course, the one related to data breach, Article 33 and 34. Well, you know that if you have an incident and this incident is related to personal data of which you lose the availability, you lose the confidentiality, you lose the integrity, this amounts to a data breach. If it amounts to a data breach and there is a possible risk for the individual, the controller needs to notify in 72 hours from the moment that the controller becomes aware. Okay. On the other side, if the risk is high, you also need to communicate the incidents to the individuals, the data subjects, the so-called communication according to Article 34. But here is another very tricky point of the integrated model. So typically, you signal something as a security incident. Okay, first and foremost, the organizations will have a trigger when there is a security incident. Then the next question, and here is already putting together cybersecurity and privacy, is to understand whether personal data are involved. And if personal data are involved, then of course we need to look at Article 33 for the possible notification, Article 34 for the possible communication. But at that point, when you see that personal data are involved, the two teams need to work together, cyber team and privacy team, legal as well, and in the management of a data breach to manage it effectively, also communication, compliance should play a role in all of this. But the point is immediately to have in the data breach management team, you need to have profiles that are both skilled in cybersecurity and skilled in legal compliance, privacy compliance, and work together to make sure that they can minimize the risk for the data subject, but also at the same time minimize the risk for the organization, also in terms of reputation, not to mention if a company is listed. We have seen a situation where listed companies will see also, some trembling of the stock price when a data breach becomes public. And also in M&A, sometimes we see M&A that completely dissolved because of the data breach of the target. Last but not least, it's important not to forget about Article 28, which is how you need to engage data processor and also sub-processors. You need to do it by way of a data processing agreement. In that data processing agreement, clear rules should be set forth in case of a breach. So if there is a data breach happening on the side of the processor immediately needs to notify the controller, and there should be a collaboration clause with SLAs attached to that in order to understand how the processor will effectively and timely collaborate with the controller. Failure to do so may result in a liability of the controller because of notification too late, for example, because there is no enough collaboration in terms of getting information from the processor. So all of this, again, requires a lot of integration between legal and cyber in order to be sure, on the one side, to choose processors that will have a high level of data security, of information security. So you need to vet them before engaging them and monitor their performance in terms of cybersecurity, but also in terms of collaboration in case of breach. So again, a multidisciplinary team, very well connected, is absolutely necessary. When we look at the European cybersecurity framework, I think it's very much noteworthy that Europe is really speeding up in terms of creating policies, in terms of creating strategy in the legislation making. And there is, the European cybersecurity strategy that was adopted on 16 December 2020. That it's interesting because it goes to cover very, very, focal points for the European ecosystem. First and foremost, it covers the critical infrastructures like hospitals, energy grids, and railway. Second point, it devotes much attention to the IoT system. So the Internet of Things, try to address the security of connected objects. Think about one chief scenario is the one of connected vehicles that are gonna pervade, our streets in a matter of few months, even more than now. The fourth pillar is about international cooperation, and the fifth one is about joint cybersecurity unit within the European Union to correctly manage, situations, cyber attacks that may hamper multiple member states. Aside from the strategy, or better to say, within this strategy, we see, the NIS Directive that is playing a fundamental role. NIS Directive that actually sets forth, specific cybersecurity obligation for member state, requiring them the creation of the Computer Security Incident Response team, the so-called CSIRT, but also quite a share of cybersecurity obligation for the operators of essential services in terms of sectors like energy, transport, banking, financial sector, health, drinking water, supply and distribution, and digital infrastructure. This is very important because if an organization falls under these kind of sectors, and more specifically, please remember that at national level, the operators of essential sectors have been codified, identified in a slight different ways from one member state to another. Therefore, it's always very important to look at the implementation at the member states level of the NIS Directive in order to understand whether your organization falls under these additional security measures. But on the other side, if your organization falls inside this, maybe you have already done quite a lot on the data protection side, or if not, if you do something in terms of cybersecurity because of the compliance with the NIS Directive, you can leverage that also in order to better comply and better set your compliance posture with respect to the GDPR and the principle of accountability. On the other side, there is already now a new proposed NIS Directive, the NIS 2, that Francesco is going to talk about in further details in few minutes, exactly in order to review the first draft and update the first draft, the first directive on the basis of the experience, and in order to make sure that it complies with the changes in the cybersecurity landscape that we have seen. Another important element of the cybersecurity framework in Europe is NISA, the cybersecurity agency that provides basically support to member states in the implementation of the NIS Directive, but also has power, thanks to the Cybersecurity Act, to coordinate member states and to offer support to the member states in case of cybersecurity attacks and threats. It's very important that the mandate of NISA has been potentiated by the Cybersecurity Act. And the Cybersecurity Act is also introducing something new, but something very interesting, which is about the Europe-wide cybersecurity certification framework for ICT products, services, and processes. And noteworthy, at the end of the last year, 2020, NISA has already proposed a candidate certification scheme that you can see freely available on their website. Here you will find the link that we have prepared for you. And this is going to be evaluated and potentially, you know, I think it is feasible to think in 2023, around 2023, this certification will come to life. And then this is going to be a massive shift because, of course, it's all about making sure that products, services, and processes will be cyber secure according to the 3 levels of the proposed certification. It does not anything to do with privacy and data protection. There is a specific carve out, a specific disclaimer in this proposed cybersecurity scheme that does not address GDPR compliance. That is going to be addressed by certification according to Article 42 of the GDPR. And in order to have a product, a service, and process secure, both in terms of cybersecurity and privacy, you will have to have both kind of certification. More to come on Article 42 certification sooner, maybe towards the end of this year. You will see probably the first EU-wide certification scheme to be approved. Ellen, the floor is yours to continue on the Australian and international scenario.
Thank you, Paolo. Well, before getting into this, I just want to say that it's obvious that the focus in Europe is all about the harmonization of these diverse approaches from the various countries. In Australia, in one way or another, we actually have an equivalent of everything that Paolo's described, but it's much more complex. What I want to say at the front is that the methodology that we're going to share with you will work anyway in Australia and in other countries. It's just that if you move from Europe, you're going to have to add one more step to that methodology. And that will become plain to you now as I go through the next couple of slides. I've only got 6 slides in total, so I'm not going to bore you to death with all these words, but just to try and tie it into the connection with Europe. What you will need to do, in essence, as that extra step, is work out what your applicable regulatory universe is. And the reason for that is that Australia, like the United States, is complex. It's as a result of federalism. We've got this patchwork of requirements. We've got different Commonwealth, state, and territory laws that are technology specific and that are also sector specific. And we need to scratch for that nicely consolidated European view across very, very many, literally thousands of laws sometimes. But the methodology is sound, and so long as you know where you fit in and you know which you need to apply to, it's relatively easy to do the matrix that gets you into the same position. But there are many peculiarities. We have different regulators responsible for different artifacts. They say you must comply with these standards or these guidelines, or you must report here in one instance or somewhere else in another instance, because some of the duties and responsibilities of the regulators either overlap or there are gaps between them, and I'll illustrate some of that for you just now. We also have differences in standards. So some of the standards come out of these regulators. And then we also have a difference between strategies and plans at a state and a federal level as well. So it's complex, but there's a very simple way to set about establishing what you need to do and then mapping it into the European model, which is now the gold standard of everything. So if we look at this particular slide, what I want to point out is this is the Australian Commonwealth and New South Wales privacy regime. And the reason I've put these two examples on this slide is that under the Commonwealth Privacy Commissioner, that body is responsible for privacy, freedom of information, and the consumer data rights rollout. There are also other issues like health and so on. But you'll see, for example, we've got 13 privacy principles under the national, or rather the federal legislation. And our Australian privacy principle number 11 is the one that deals with security of personal information. It goes further. It even describes what might be secure or not in terms of, is it accessible? How easy is that information accessible to somebody, and what's the kind of person or body that's trying to access it? So there are definitely guidelines, but there are also real quirks and carve-outs here, because we have a threshold. It doesn't even apply unless you're doing, more than $3 million a year. In terms of the reporting, the eligible data breach, we call it, but it is still mandatory. You only have to do it if there is likely harm of serious risk to an individual. And yes, then you need to report to various bodies, and there are several involved. You only need to do it when it's reasonably practicable. If you're not sure and you only suspect that there might be a breach, you've got 30 days to do a full assessment as to whether there is. You also have a second opportunity to say you can rectify prior to there being any harm. So there are all these quirks that come up, but the point of it is that the threshold and the applicability mean that certain aspects of our society are completely, this doesn't apply to them at all. In the case of the New South Wales state, we have recently just had a bill proposed there which models the data breach requirements from the Privacy Act. In fact, it follows in many circumstances the same approach. Carl, if you go to the next slide, please. This slide will show you that all of these different states, now we've got 6 states and 2 territories, all have their own version of state privacy laws, all with their own regulators, all with their own peculiarities. The definitions of personal information in terms of a legal definition are not necessarily the same, but the essence of a person is either identified or identifiable does apply. But you can see how complicated it is. Now, it doesn't really matter where you fit in the supply chain of business. If you are providing a service to or involved in either a state government or federal government, you become part of that supply chain, and therefore you will be held to a higher standard. And we see this in Europe too. You must make sure that if you are in that chain of controller and processor, that everybody in the chain behind you is equally careful as to how they manage the security and privacy of the information. Please go to the next slide, Paolo. Now this one, I've moved to the Australian Surveillance Regulatory Framework. Now, this is often not spoken about, but I'm introducing it specifically because of the NIS 2 requirement, which you'll see in a second. Australia actually has one of the most stringent surveillance regimes that I'm aware of. The other one with really stringent requirements was South Africa, where I started in this field. But now, while these various bodies and laws actually make it legal for interception and monitoring and surveillance to happen, you'll see a number of things that are important. firstly, Australia doesn't recognize convergence between broadcasting and telecommunications law. So you've got telecommunications laws here that deal with switched networks and live communications. Then you've got other telecommunications laws that deals with metadata and stored communications. And then you've got data surveillance, which is all your IP information. And it's all handled separately. And again, we have various data surveillance laws that are different in the different states. The important ones here to watch in terms of working with Europe are the one that I've got called TOLA. It's 1, 2, 3, fourth on that list, because that actually requires anybody providing services, and they're international companies as well, to do what they call, it's not a very clear definition, but the legislation says acts or things in order to enable access to any information, even if it is encrypted. So there was at the time that this was under discussion, quite a lot of debate about, backdoors and weakening the systems, et cetera, Be that as it may, it is in force, and that is the situation. The other one that is pending is this new one where you can disrupt, the powers that be can disrupt, modify, change, and even bring technical aspects into the ability to surveil or to disrupt and attack. And then the last one you need to know about is the clarifying lawful overseas use of data, which is an American, really the basis for a bilateral treaty. Now, the only other country that's entered into agreement with the US is the UK. It is likely that we will be the next, and essentially that opens access for those 3 countries to share data and make it available no matter where it is, no matter where it resides. So some really powerful legislation that you need to keep an eye on with respect to processing European personal information here. Next slide, please. And this is the point that I wanted to make with that, with the European Commissioner saying that the standard contractual clauses are being beefed up and they're looking at transparency and accountability. That's all very well, but it also does go to say that the European processors and controllers need to make sure that they protect the personal information from being accessed by governments in third countries. And here you're going to have to do, essentially, you're going to have to do more and buffer up your standard contractual clauses, but it doesn't get away from the fact that we have this legislation that in any event will allow decryption of information. So there's some work to be done here. I always found it interesting that by comparison, when you had the United States and you had the old safe harbor and then the privacy shield, that effectively was endorsed by the US government that ensured that European citizens had right of recourse. There's never been such an arrangement here. So some of the things we need to consider. All right, then one more slide, please. Now this slide is very simple, but it's a good example to demonstrate to you where the different powers sit. I'm not going to spend so much time on the first column, which is the Commonwealth. It's merely to say that they have their own security framework. They've got the Information Security Manual as well, which they just done a new version of. And then this Protective Security Policy Framework that caters for security of governance, information, personnel, and physical security. That is echoed in, and just one example, the state of Victoria, which is where our office is in Melbourne. Similarly, a special standard that needs to be applied. And when you find services between state and federal government and outsourcing, these kind of things become really involved because you have to thread out who's doing what. Importantly for this discussion is the right-hand sector, and it's an example, because Australia is too complex to deal with them all, of the FinSec. So APRA, which is the prudential regulator that looks after all of the banks and insurance companies and deposit-taking institutions, has issued a number of what they call certification practice statements and certification practice guides. And so, for example, the first one, CPS 234 on information security, says the board of an APRA-regulated entity is responsible for security, and they have to do very particular things, including watching that supply chain risk management all the way down the line. So you'll see how where Europe's got a bigger, better consolidated whole view on things, we have these bits and pieces. Some of the other APRA ones go to managing security, risk management, data management, etc., and outsourcing also, which is important. And ASIC, which is the regulator in charge of corporations, so Securities and Investment Commission, they've got reports on resilience and hygiene and so on. So you're getting each sector saying, this is what we need you to do. So there's a tremendous amount of duplication, and sometimes they're not exactly the same. All right, I think I have just one more slide to share with you. This one I've put in because it demonstrates nicely how everything comes together. And if you picture, if you look at the column on the right-hand side, you'll see that we've got at the bottom, so look at the bottom right-hand corner, we've got Treasury. So the Treasury, the portfolio that falls under Treasury, is responsible for the ACCC, the Consumer Commission, the Prudential Regulator, and the Corporations Regulator. And what I've described then, if we move across to the laws, there are certain laws that each of those bodies are responsible for. And if you move further to the left, you'll see examples of those standards and guidelines that I've just mentioned. So you can see how specific it is to a ministerial portfolio, but also to a regulator. It also means that you've got very particular reporting responsibilities to these different entities. If you go one row up, where we've got the Attorney General portfolio, you'll see that the Privacy Commissioner actually sits under the Attorney General's office. And he's responsible for, she is now, responsible for the Privacy Act. And they then have drafted the Guide to Securing Personal Information and the CDR Privacy Security Rules. So the OAIC, the Office of our Privacy Commissioner, and our corporations entities are very tied, and they've got these slightly distinct functions and responsibilities. What happens, though, in terms of threading out the entire infrastructure and how you're going to get this regulatory framework into shape is hugely impacted by the new reform to our critical infrastructure law we had in 2018. Now we've got a draft for 2020. And this goes to what Paolo was telling you about just now on essential services, because we've got initially 3 services, but they've actually recognized 11 critical infrastructure sectors altogether. And that puts a layer on top that essentially everybody that plays in these fields needs to actually lift their game, as it were, to a higher standard of security. So we're going to see very big changes. But again, in summary, I think that they are parallel to the European situation. It's just more difficult to thread them out. But once you have established what your regulatory universe is, what the laws are that you have to comply with, you can consolidate it and treat it exactly the same way as the Europeans do, and particularly in what we're sharing with you with an integrated framework. So that's that for me. Thank you.
Thank you very much, Elena. So we proceed with major sanction within the European Union, and we leverage our service of global privacy news. We have a service for our clients where we monitor every decision by supervisory authority with respect to the GDPR, but also going beyond the Privacy Directive. And are systematically also looking at, the global landscape in terms of enforcement by supervisory authorities. So the result of this observatory that we have give us the possibility to draw some interesting analysis on risk exposures to sanctions. So analyzing over 650 enforcement actions, starting from the 25th of May 2018, we can see that the most recurrent single cause of sanctions under the GDPR is violation of Article 32, adequate security measure. Why I'm saying Article 32, and you see in the graph in the chart that Article 5 and Article 6 have a larger portion, simply because Article 5 is the article setting for all the principles on privacy and data protection. So it's not a single obligation, it's a multiplicity of obligation. And usually when you see, for example, violation of Article 32, it's always in combination with violation of Article 5, which is the principle of security. Article 6, again, is a combination of obligations, because Article 6 set forth the lawful ground to process personal data. So this is also typically referred to when you have, for example, sanctions for unsolicited marketing communication. You will have a violation of Article 6, maybe coupled with Article 13 because of lack of transparency in the information notice and privacy policies. So given that 5 and 6 are a combination of obligation, the next one is Article 32, which is a single specific obligation of securing in an adequate way personal data. Adequate is related to the concept of risk assessment. So you can only provide evidence of adequacy. It's not an obligation of result, it's an obligation of means, and it is treated like that by supervisory authority. But in order to discharge your obligation, you need to show that you have done an integrated cybersecurity and data protection risk assessment and have put in place enough mitigation measures in order to prevent the possibility for the risk to materialize, or that if the risk materialized, you have correctly managed the situation. And as I said before, circa 70% of the cases where companies have been sanctioned for violation of Article 32, so inadequacy of the security measures, originated by a data breach that was notified to the authority. The authority then started an investigation. The investigation signaled through the root cause analysis that there were not adequate security measures, and therefore the sanction was eventually on Article 32, sometimes in combination with Article 5. So very important from our observatorium that you secure the personal data, because it's the single highest cause of sanctions in Europe. And when we look at sanctions, these are very, very high sanctions. This is the list of the top 10 highest sanctions so far issued in Europe. And we have indicated with an arrow every time that Article 32 was one of the reasons of the violation. So getting into, for example, the case of Telecom Italia Mobile, one of the major Italian telco operator, it was found because largely, violation of the regulation related to unsolicited telemarketing and marketing communication. But it's very important and noteworthy that the Italian Data Protection Authority, which by the way is very active, you see the Italian Data Protection Authority showing up 4 times in the top 10 list. And then you see also the French CNIL, very active, the German authorities, the Spanish authorities. UK now is out of the European Union, but really like Germany, Spain, Italy, France, they are very, very active in terms of sanctions. Anyway, going back to the team situation, the violation of Article 32 was about the fact that the team did not have in place adequate procedure to correctly manage data breaches. So data breaches were always identified too late, and too late brought to the attention of the data protection officer to start, the contingency plan and the reaction and the notification to the authority and the possible communication. That's an important aspect. On the British Airways sanctions for the data breach, I think most of you will be familiar with that. Also in terms of, the approximate amount of data that was close to over 400,000 British Airways customers and staff, including their name, address, payment details, CCV numbers of 244,000 customers. So British Airways was fined for inadequate security measures. But one sanction that I find very interesting, and I also spot a question on that, is the one related to the Marriott International, because the Marriott International was fined for a violation of Article 32 due to a data breach. So again, starting from Article 33, then the violation was in Article 32. But the point is that it is believed that this data breach, this vulnerability of the systems were related to the system of the Starwood Hotels Group that was actually acquired by the Marriott in 2018 without doing a proper cybersecurity and data security due diligence. So they acquired the company, as it is the case in many situations, especially after the COVID pandemic, where some companies are getting weak and therefore they become the target of bigger and more consolidated companies running quick M&A without proper due diligence, integrating the systems without even understanding that they are bringing a big issue inside the acquiring company because not proper due diligence have been made, and so on and so forth. This is a super important point. We usually act as special advisor in M&A related to databases or large IT infrastructures and so on and so forth. How important it is to run a proper due diligence during the M&A process, during the negotiation, also because this is going to massively impact the price of the target. If you are acquiring dirty databases, databases that have not been collected properly, instead of realizing an asset, you are actually doing completely the opposite. You are bringing a problem inside your company and you are thinking that you are getting some value out of it, but actually you are not getting any value because you need to reach out again to all data subjects in order to get proper consents and so on and so forth, with all the difficulties related to it. But the same goes for data security. If you haven't run the proper due diligence in terms of data security, your risk in terms of violation of Article 32, your risk in terms of being able to cope with the obligation under 33 and 34, and more generally in terms of business continuity and productivity of your company is really, really exponential. But we see still that there is not enough attention. If there is attention, then of course in the shares purchase agreement, you can have the correct reps and warranties, you can define the right price and so on and so forth. So this is a very, very important phase of an M&A and very often quite disregarded. We see also a lot of attention by supervisory authority in making sure that companies are notifying within the 72 hours. Here, I think it's very important to define when the 72 hours will start. And usually what we do with our clients, we set up 2 units, the data breach assessment unit, composed by 3-4 key stakeholders, like a stakeholder that is very knowledgeable about cybersecurity and IT. On the other side, another stakeholder that is knowledgeable about privacy, like the data protection officer, and depending on the breach, the product owner or the service owner, the one that knows the specific subject matter. So those people will need to assess whether the incident involved personal data in a fairly short amount of time, 24 hours, 48 hours max, from the from the time that that there is an incident. When this unit establish that data are involved, from that specific moment, the 72 hours start to run. And within 72 hours, you need to make sure to do at least a preliminary notification. You know that there is this scheme of notification in phase. Don't postpone the notification until you have all information, because sometimes by way of experience, not even after 1 month, you have all information in order to report all the details to the data protection authority, especially with large and sophisticated attacks. So very important to be timely. Remember, you can notify in phase. You can always do updates to your notification until you have the whole situation under control. Here you see like 2 sanctions because of the delayed notification by the Dutch and Spanish authority. On this slide, a very recent fine to Virgin Mobile Polska. I want to discuss that because this is also, to my eyes, super interesting and super timely, because Virgin Polska was basically fined for violation of Article 32 of the GDPR, so inadequate security measures, because it was not running preventive audits was only doing reactive check to their data security posture after incidents. This is signaling something very important for all organizations. The supervisory authorities, in order to see that you fulfill Article 32, adequate security measures, Article 5, the principle of data security, but also more generally, the principle of accountability, following the risk-based approach according to Article 24, this entails regular audit on data security measures, also in case that no threat has been identified. So this is, I spotted another couple of questions about audits and how regularly an organization should check for security measure. Well, I would say at least once a year, at least. And then, of course, if you are subject to specific attacks, immediately afterwards, then you need to re-verify and improve your data security and cybersecurity compliance posture. So remember, the Virgin Mobile Polska is telling us how important it is to do regular audit on data security measures, even in case there is no incidents. So now we get into highlights of the methodology to create an integrated privacy and cybersecurity compliance framework. Francesco, please, the floor is yours.
Thank you, Paolo. First of all, let me say thank you to you and Elaine. It is extremely interesting, this topic, and I believe that sharing this type of thoughts is of profound benefit to the legal and cybersecurity community, especially as we are about to face ever-growing challenges and to play an undreamt but not unexpected role of centrality within society. There is an extremely transversal concept in order to talk about an integrated cybersecurity and privacy framework, which has technical implications, which has IT implications in an operative sense, but also, and above all, a sociological implications regarding companies, which is the concept of trust. Why the concept of trust is relevant in building a data protection and cybersecurity framework? Because trust is one of the key elements that encompass a business leverage. The concept of an integrated cybersecurity and data protection framework, therefore, has to start from there. As recently stated by literature, Harari, Sapiens, trust is one of the key elements for the development of an orderly society, an orderly company. And I mean, trust can be manifested towards a composition society, which is conceptually the same thing as a legal system, can be manifested towards people, towards companies, representing an asset in order to increase companies' income through end user engagement. At the end, trust can be manifested towards elsewhere, beyond, but quoting the Greek beauty, we don't deal with beyond. What we are concerned with is the interaction between the legal system in which we place our trust and the processes that regulate it. In other words, what technology is today, or if we want to be broader, technological progress and how to protect our asset through it. We can move one slide. Thank you, Paolo. As can be seen in the projected slide, in terms of legislation, the European legislator has been able to regulate the issue of data protection and cybersecurity from different point of views. First of all, from the data protection perspective, regarding personal data processing through the regulation that is known as GDPR. Secondly, with NIS Directive regarding essential services and digital service providers, and we will come back to that later. Thirdly, as we already saw through the Cybersecurity Act and giving a robust framework to the process of certification for the products. There are also other norms like European Electronic Communication Code, which applies to certain companies and certain businesses. We can move to another slide just to see that the work that has been carried out by the European legislator relies on the same concepts, focusing on personal data, on information as an asset to be protected. Especially within the framework of the NIS Directive, we can notice that the European legislator tries to generate trust in the most important companies of Europe, regulating them in order to guarantee business continuity to its citizen through a cybersecurity strategy based on risk assessment, which is the same that is encompassed by Article 32 of GDPR. What permeates our contemporary society, therefore, is the desire to dedicate trust to technological processes. And this concept, for those with a legal background, I mean, is implied in the knowledge of the rules, which allows them to extend their trust in the system. But due to the fact that the information technology is information security, and security is by its very nature the verification of the reliability of the trust placed in technologically regulated systems and processes, a company has to understand how to regulate this intersection among the two worlds. Cybersecurity and personal data protection regulation are strongly influenced by this concept. And although they seem to run on two parallel tracks, they meet, they intersect, they come together in a combination that becomes a competitive advantage. And I mean, rethinking NIS Directive, it's an expression of this interaction. We can go to the other slide. Just to see that with the considerable growth in cyber attacks, and in some cases, the corresponding increase in investment in technical security measures like firewalls, antivirus, the so-called attackers have therefore decided to exploit companies' trust in their suppliers in order to conduct malicious activities. The European legislator trying to prevent supply chain attacks, this is how it's called an attack conveyed to our suppliers, have several tools in its hand. The tools in the hands of the legislator evolve along the evolution of threats. And the recent growth of attacks on the supply chain, even just to answer to a question that has been asked, even in the US, as seen with the famous SolarWinds case, it was a supply chain attack. These have led the legislator to rethink the regulatory approach, focusing on some paramount, on some salient aspects through a re-elaboration of what is contained in the NIS Directive, aimed at issuing the so-called NIS Directive. We can go to the other slide. Therefore, this concept of computer security as vehicle for verifying trust is briefly explained in one of the most known security measures, which is authentication. Some of you asked about authentication and how to force it. I mean, let's ask, why do we authenticate ourselves after all? What should we guarantee and why while we authenticate ourselves in a system? It is clear that we are doing during the authentication ceremony is to get into the system and to get the system to trust us and the user to trust our company. As you can see, therefore, it is precisely the concept of trust that lies at the basis of the most basic measures of computer security, of one of the cornerstones of computer security, which is authentication. The concept of authentication itself relies on the concept of personal data, of who we are, on how company manage those information. And just as the system needs to gather elements to increase trust in its user, so the user needs to trust the system and therefore the company, both from an economical and sociological point of view, both from a cybersecurity and data protection point of view. This concept can be in parallel extended to the supply chain topic. In fact, the trust of companies in their suppliers often entails an increase in the likelihood that a threat can be expressed in the exploitation of a vulnerability of a supplier, causing damage that, in addition to having legal consequences, as Paolo already described, has business consequences, having a negative impact not only on the production of goods and services, but also, and sometimes above all, on brand reputation. This is because a system that is not considered reliable, worthy of trust, is not used. We can move to another slide, please. Thank you, Paolo. The European legislators' focus on third party, however, is not only related to the cybersecurity aspects. In fact, third party management is only one of those intersections that I already mentioned. Third parties, suppliers, business partners, their security in terms of cybersecurity and in terms of personal data protection is to be considered in a broad sense. On the one hand, GDPR, in fact, imposes assessment on data controllers. Those who entrust third parties, the so-called data processors, with the processing of personal data, they have to guarantee compliance with the provision of the regulation. And even in terms of the potential not to cause damage from a cybersecurity point of view. This type of assessment, therefore, becomes useful from a legal point of view, making the companies that carries it out with such a dual perspective compliant with the rules, but even from a business protection point of view, because it leads companies to choose increasingly reliable suppliers, drastically reducing the probability that a supplier can cause damage to the company's information assets and therefore to the company itself. And this is how our legislator tries to implement its strategy. Therefore, NIS Directive and GDPR have in common Article 28 and this approach to supply chain. And while implementing a framework of compliance in data protection and cybersecurity, we have to take that in consideration with a business focus. We can move to the other slide. Thank you, Paolo. So, taking into consideration that although the European legislator can strengthen the principle and create obligation to protect companies and critical infrastructures and to lead us in a compliance path, cybersecurity is one. The regulatory framework has the function of reinforcing the awareness related to cybersecurity, imposing sanctions where necessary, but leaving to other branches of human knowledge the solutions at the operational level for the implementation of regulatory principles. And that is why an interdisciplinary approach that encompasses a legal perspective and a cybersecurity perspective in a risk assessment approach is necessary in order to create an integration that comes from the governance. Building a cybersecurity culture in organization through setting up an integrated framework of compliance from a legal cybersecurity perspective is a competitive advantage. It is clear the trust in organization move towards the creation of a culture of information security within the organization itself. And that can be created only through an interdisciplinary approach to the governance of the company, implementing a system that encompasses the governance of the company with a data-driven approach and from a risk approach perspective. Therefore, trust in the process, in its being firstly adjustable, secondly regulated, allows for a cultural change aimed at preserving the company. We can move to the other slide. Thank you, Paolo. Often, companies rely on certification, like ISO 27001. Those certifications that are guidelines to implement systems that are reliable, trustable, can be integrated with a cybersecurity and legal compliance with the European law. And this is a further manifestation of the concept of trust and a further manifestation, demonstration of the possibility to integrate a compliance framework, both from the data protection perspective and cybersecurity perspective. The creation of the interaction between human and technology within an organization, aimed at first at creating goods and services in compliance with the law and protected by the system that processes information and personal data. It is paramount and can rely only rethinking GDPR and cybersecurity compliance in such a way to enshrine a business advantage. in order to build a leverage for the business, to engage end users, which are increasingly interested in the protection of their data, of their information, and also to be compliant with norms and regulation at the European level. What the company system is made of today is also easily identifiable. We do not resort to any studies or analysis right now. In our experience as ICT legal consulting, every day we deal with small, medium, large, multinational companies that are even leaders in their sectors. We know that the company is a complex ecosystem, but whose lowest common denominator is always being composed of network, infrastructure, application, people. And the system that regulates its processes has to be implemented with an operative perspective. Approaching this with a risk assessment methodology that encompasses legal risk, cyber threats, and business opportunity is the activity of building an integrated framework. And it means giving the company and the managers who operates in the company to carry out a transformation from risk to a business opportunity. To sum up, first of all, it is important, and we can move to the last slide. It is important to analyze the processes within the company, starting from the governance, because the governance will lead the transformation in the company. Then assess the risk and build a management system that can lead to identify the areas in which to invest. This will lead several times to certification as ISO 27001 and to compliance from a GDPR or NIS perspective, and from an operational perspective to security, from a business perspective to build trust in our customers, to increase our income, to increase our business. And to see how, I leave the floor to Paolo, because we will see how the return of investment in privacy and cybersecurity, it is important.
Thank you, Francesco. So with respect to privacy and cybersecurity, as Francesco said, this is not anymore just a legal requirement, but it's a business requirement. As Francesco correctly said, consumers expect that, but also business partners expect that. And if you participate in public tenders, the public administration expects that as well. We'll see more and more requests for offer through public procurement, but also, procurement by large organizations, strictly imposing compliance with GDPR and very high standards of cybersecurity, information and data security. So it's a way to stay in the business. And the better you do, the more competitive you are and will be in the next future. It's also about building accountability, which is fundamental in our European data protection compliance system. Is about increasing trust, of course, of the customers, but also to make sure that, as I mentioned, you will stay in business and you will be able to develop the business in a way that is coherent with the European and international privacy framework, and that you will be a reliable business partner for other parties. Interesting from a Cisco recent study that for every $1 spent on privacy, there is a return of more than $2.5 in associated benefit. Associated benefit are in terms of compliance, in terms of accountability, but also in terms of spending less in managing data breaches and all that comes with it. So I think according to my experience, something that is very difficult is to share this type of information with the top management, because at the end of the day, it's about budget. So there are many clients that say, if I would have this budget, I would do A, B, and C, but I don't have. I have half of it, or not even half of it. How can I communicate through a sort of elevator speech in a few seconds, in a couple of minutes, to the board of directors, to the CEO of my company, how important it is to be cyber secure, how important it is to protect personal data? Well, I think that pitch presentations based on, the top 10 sanctions, the graphic that we are able to display because of our observatory of the, now over 650 sanctions in the world, with the rationale and the pointers of the related risk, as well as, giving some figures about what is the cost of data breach and what is the possible return of investment on privacy and data protection, I think is very important. Even more important when certifications on privacy will be out there. And once again, we are involved in especially one of them. Hopefully this is going to be, a reality in Q4 of this year. And this is going to change completely the game, because then, of course, everybody's after certification. In order to get certification, you need to show accountability and compliance. And therefore, everything that you would have built before, with respect to increasing your data protection compliance posture, will be capitalized by receiving that certification, which is much wanted, by the business partner, by the public administration, by the market. So that's also very important information that the top management of a company needs to know. The time is now to invest in order to increase the compliance posture in terms of cybersecurity and data privacy, because when certifications will be out there, your company or your organization would be potentially one of the first to be able to leverage that, capitalize that, and create, a very significant and clear return on investment. Francesco, maybe you want to spend a few words on the return on security investment.
Yes, thank you, Paolo. Really few words, because in recent years, numerous attempts have been made to define a mathematical method to calculate the costs and return of investment in security initiatives. It is called return on security investment, which contains two key indicators. The first is the key cost indicator, which is an index used to measure the performance of processes. And this is useful for calculating the cost, and can be used in an integration with ISO 27000 compliance risk assessment. The key return indicator, which is the efficiency in terms of ISO 27001, is used to measure the performance of the processes, and is useful to calculate the return and to justify the investments. In ISO 27001 compliance framework is defined by KPIs, but if we translate it in measures in order to understand the return of investment, can be useful to justify our investment. We can move to the last slide. Thank you, Paolo. Therefore, how can we calculate? There are several methodologies, and they really depend on the system that the company implemented. If it's an integrated system that relies on ISO 27001, on GDPR, on NIS Directive, or in Italy to cybersecurity perimeter, first, we start from the identification of costs, the definition of KPIs, which is useful for the compliance and to evaluate our security measures in terms of technical or organizational security measures. And then the identification of possible metrics, which is contextual to the identification of threats. Then the definition of new metrics that are according to the process and to the business continuity that the process has to have. Then the measurement of the metrics and the index assessment within a risk assessment framework methodology. This is how we can, it's a methodology that we propose, but there are a lot of methodology based on several standards. Therefore, it is really subjective for the company in order to understand how to move in the return of security investment and how to assess it. I leave the floor to
So
conclusions.
we briefly conclude. I think we made the point based on facts and figures and our experience that data security is of massive importance for organization. Surely, first single cause of sanctions under the GDPR. Having a correct and adequate compliance posture with respect to cybersecurity and privacy is just not only compliance requirement and legal requirement, is a business requirement to stay competitive. Another thing that is very important is to understand that there is a concrete return on investment if you deploy resources on cybersecurity and data privacy, even more when certifications will be out there to fully capitalize and show to the market, to the consumers and the business partners and the possible public administration that you want to offer service to, that you are up to the expected standards. Next frontier, because we always look ahead, is not anymore enough to look at privacy and cybersecurity, but you need to mix them as we are mixing that with, and integrating them for our clients. But the next competitive level is about data protection and data security as a corporate social responsibility. There is a study that I conduct, and it's in its second year of Maastricht University, the European Center on Privacy and Cybersecurity, that has created 5 principles and a number of rules in order to have a framework to be able to audit organizations that process personal data and secure personal data in a corporate responsible way. And guess what? Principle number 1, rule number 1 is about implemented data security by design. This is an expectation of our data-driven society, and it's a requirement to stay in a data-driven economy. With that, we thank you very much for the attention. And if you agree, I will move to the chat to try to answer as many questions as possible before the time is over. So let me get into the chat and start from the beginning. I will act a bit as a moderator if Elena and Francesco allow me to do, so that the answer that I can quickly give, I will do it. And then I will, depending on, competencies, I will just pose the question to one of you. So first question, with tech and risk constantly changing, what's the best way to stress test how vulnerable a company is to a cyber threat or a breach? Well, I think Francesco mentioned the constant evolving landscape of cybersecurity. This was also testimonied by the NISA recent study that we indicated in our presentation. But the short answer to the question is with a regular vulnerability assessment and penetration test, at least annually, or after an incident, of course, to make sure that you can have adequate remediation measures. Regular audit, please learn from the Virgin Polska case that we mentioned before. So regular audit, at least yearly audit, even if there is no problem, even if your organization haven't experienced any problem. Trainings to workforce is very important. We suggest phishing campaigns. They are really, really important in this moment to make sure that you elevate the attention and bring the result to the boards and to the top management to show that, sometimes the very dramatic result that we see after we run phishing campaigns within our clients. Second question, how do the panel advise protecting sensitive information handled and stored by third-party vendors? Well, here I think Francesco mentioned how important is third-party management and I would say third-party assessment before engaging third parties like data processor, external suppliers. Sometimes, the compliance and the DPO function of the company are just involved at the end of the deal when the vendors have been already decided or at least shortlisted, and there is no possibility anymore, to run a proper due diligence, or at least to share a checklist in order to be reassured about the security measure on sensitive, read also special categories of personal data, but even more like a concept of sensitive information like financial information, business information, geolocation information, and so on and so forth, like in the last guidelines on data protection impact assessment of the former Article 29 Working Party. So that the key here is to have third-party assessment procedures in place, then the possibility to monitor them, as it is also requested by Article 28, monitor their compliance posture through derogation of the service, and very robust data processing agreement. Okay, so that's the answer to my answer to this question. A third question: with everyone worldwide working from home for the last 12 to 18 months, what new threats have emerged? How threats become more sophisticated? Well, I think here Francesco already mentioned the supply chain attacks have been, exploding. I would add phishing and ransomware, crypto lockers attacks as well. I don't know, Francesco, if you want to add something more on this.
Yeah, Paolo. Yes, Paolo. As you said at the beginning, thanks to social engineering, attacks are more sophisticated. And social engineering can be carried out due to the fact that we stayed at home. And therefore, our communication relies not only in seeing us face to face, but through Meet, Teams, Zoom, and other tools in order for us to communicate. Therefore, man-in-the-middle attacks increases too. Man-in-the-middle is an attack that relies on the possibility to listen to a communication. And listen to a communication gives information, which is power, in order to conduct other attacks like spear phishing, and in order to inoculate a ransomware or a spyware in a company.
Yeah, thank you, Francesco. Then next question is, how is the use of social media going to impact how company handles communications around a leak or a breach once it is in public domain? Well, I think here you have two aspects. So one aspect is about monitoring social media and social media communication after a breach is out there, because you can have a lot of discussion on social media that potentially hamper and undermine the reputation and the trust with respect to your company. And therefore you need to deploy massive engagement of social media managers, try to promptly react on the corporate social media profiles, and making sure, and this is the second point, that you have also available resource to refer to with respect to who is asking questions on social media. So whenever there is a data breach, especially large data breaches, one of the first things you need to set up is a source of information that could be publicly available, like a dedicated page on your website saying, look, here is where we refer to anybody that is asking about what happened. Okay, so it's a huge work, but there is a lot of return in that investment, because there is nothing worse in a data breach of unclearness. If the data subject will become, afraid about what is going on, they're not telling me the full story, I don't see available information, they don't answer the phone, I send an email, they didn't reply, so maybe they're not doing anything, they don't care about me and my data. Completely opposite is if you are proactive, that you make a press release and say, this day happened that, this is the reason, and we are working around the clock, to minimize the impact. Here is the website where we put, all the information, and every day at a specific time, it is updated. Not it is updated when we feel like, because the people will get impatient. It is updated every time at 3 p.m., every day at 3 p.m. That's another very important element to reassure the individuals. Last point is that, there is no specific way in which a company needs to share information about data breaches to data subjects. Therefore, you can also think about leveraging the social media and your corporate accounts to inform your followers and say, look, guys, something bad happened, but we are really, committed to solve the situation, minimizing the risk. We are still, a trusted brand. And as a trusted brand, we acknowledge that this has happened in a very transparent way, and we're doing our utmost best, to solve the problem and minimize the risk and keep on doing business as we did before, even better. And then again, a link to say, if you want to have more information, there is this specific call center. There is this web page where we have, a number of information published and updated every day at 3 p.m., for example. Okay, so the time is over. We are trying to do our best to answer everything. It's 5:30. We need to close. I want to thank you immensely, Hélène and Francesco, for sharing your knowledge and expertise. Thank you to Legal 500 for hosting us. We hope this has been informative. You have our email addresses. You can post directly questions to us. We'll do our best to get back to you on as soon as possible. So all the best and stay cyber secure. Bye.
Thanks very much, everyone. That was brilliant.